Oh, hey friends. Josh Yeager, Santa Barbara dog walker, and a state vault black belt. On a walk with my buddy Dodger. Hey Dodger! Dodger! Hey! Hey buddy, come here! Come here, Dodger! There's the good boy. Ruben from Manteca asks, hey Josh, what's the deal when settling Dad's estate if he has assets in another country? Well, glad you asked, Ruben. That's a ticklish issue. If the estate is modest, below the lifetime exemption where no estate tax is going to be paid, including the valuation of the size of the estate with the non-US assets. So let's do a hypo and say Dad's got $5 million in the US and $1 million in Mexico. Dad dies, question, what happens? Do we owe any tax? Do we get in trouble for that? Answer is no. You don't owe any tax and you don't get in trouble. There may be a settlement problem in Mexico, like how do you actually change title of an asset in Mexico? What are the testamentary instructions? Do the testamentary instructions of Dad's estate plan in the US apply to the Mexican assets? That's a different issue. But as to the tax issue, so long as Dad's life or worldwide assets, US and non-US, so long as those are below his exemption amount, then there's no tax. But the US is one of the few countries in the world, perhaps the only country, that taxes on world wealth. So that begs the question, how's the IRS know that Dad's got any money in Mexico? Well, there's a couple of ways. One, they will know if Dad is honest on his tax return, because there's a box that you check on your 1040. Do you have any non-US assets? If Dad dies and we're filing an estate tax return, a 706 tax return, the same question is asked. Are there any assets that we should know about that aren't in the US? Because the estate is everything. It's not just what is in the US. So if you're filling out the tax return and Dad has assets overseas and you're willing to lie, no problem. IRS will never find out about it unless they do, in which case you could get in big trouble. I was involved in a state settlement where the little old lady had a couple $1 million stashed in Switzerland. She had never told anybody about it. And then when she died, the IRS took umbrage at the fact that she hadn't been entirely honest with them over the succeeding years and charged the estate about $500,000 in back taxes and penalties that should have been paid for 20 years of interest on the Swiss assets. Now, how did the IRS find out? Well, there's something called an international tax treaty, which the big boys, the US, have with the little boys, everybody else. And the tax treaties go something like this. If we ever come knocking, we being the IRS, and we ask about international bank accounts that people that we have jurisdiction over, our citizens, our taxing authority, if we ever come asking, you have to divulge to us the details of who owns the assets and what are the assets. And there are long-standing, like 30-year long-standing agreements. Hey, Dodger, we're going to go this way now, bud. Long-standing agreements that force the other jurisdictions to comply. So, if you got money stashed in the Philippines and anyone ever audits that tax return, the estate tax return for Dad, or finds out that Dad's been lying when checking the box, no, I don't have any other assets that I remember at all. It can be a scene. Now remember, there's nothing wrong with having assets overseas. The two issues are you honest and disclose them on the 706 estate tax return when filing it? If it's a small estate or an estate below the exemption amount, you might not even file that return. You might decide, no worries. Dad's got a $5 million estate and a $13 million lifetime exemption. No sweat, we're not going to file a tax return and disclose the non-US assets. That might be hey Dodger, don't eat the bird. Dodger! That might be an example where you want to file the 706, even though you don't owe any tax. You're doing it prophylactically to let the IRS know, hey, there are assets in Costa Rica. They are non-taxable because my exemption amount is higher than my cumulative estate, but just wanted you to know so we don't get any fights in the future with my kids or my widowed wife. So be advised, and the subset issue is may not be tax. If there is tax, trust me, the IRS is going to find out about it. The international tax treaties are used all the time. The data request from the IRS to some foreign bank is easily done. They process hundreds or thousands of them per week. The data flows easily. Don't pretend that because nobody else knows you have a big account in the Philippines that the IRS isn't going to find out. Second issue, if you're non-taxable, no estate tax owed, the issue of does your language in your trust doc or other dispositive instructions in the U.S., does that control the disposition of your assets that are not here? Not being an attorney in the Philippines or Mexico or Costa Rica or Panama, I'm not the right guy to ask. But just thought you should know, if you have assets in any other jurisdiction, probably should talk with an attorney of that jurisdiction and get their update on what the expats do. Okay, folks, that's all I got for today on the Estate Vault Dog Walk. Check out more riveting details at estatevault.com. Ciao.